Good afternoon.
Good afternoon. You see, tell something about yourself to us.
My name is Shalabdeep Goyal. I belong to Sambhal, Uttar Pradesh. I have completed my schooling from Sambhal, completed my LLB and LLM from Banaras Hindu University, and currently pursuing PhD.
You appear to be a religious person reading Bhagavad Gita. Huh?
Yes, sir.
Very good. Very good. Why do you want to become a judge? What drives you
Sir,
to become judge?
sir, as a judge, a person gets the opportunity to hear both the sides, and on the basis of evidences and arguments made before it, he imparts the justice and runs the administration of justice. So this thing drives me to be the part of Indian judiciary.
Okay, good. So tell us what is the difference between culpable homicide not amounting to murder and murder?
In both conditions, there is a killing of a human being. The major difference between culpable homicide not amounting to murder and murder is intention. In case of murder, the intention is grave. A person causes the death of a person with an intention, with a grave intention. However, in case of culpable homicide, the intention is not considered as so much grave.
Any other difference?
Yes, sir.
Intention, you
In
say
case of
intention.
culpable
Where there is
homicide,
intention, there is always murder. You say this. Any other
yes, sir.
difference?
So, in case of mm, intention, in case of murder, a person always knows that whatever injury he is causing, that is mostly likely to cause death. However, in case of culpable homicide, this type of intention is absent.
Okay. Can you elaborate further? Have you read Rag versus Govinda? Case,
Yes, sir.
very renowned case on this.
Yes, sir.
Actually, very everything they written there. Intention, nature of injury,
So,
knowledge.
nature of injury also depends
Whether it is a
in
likely
order
death
to.
or in all probability, there is great difference between this likely to cause death in all
Yes, sir.
probability, in all circumstances. Is so
Yes, sir.
dangerous. In all probability, it will cause death. So this kind of
Okay.
where will you find this? This is not amounting to murder. This is murder. It's subtle difference, but we have to find out on the basis of the injuries on the
Yes,
body.
sir.
But part of the body he has chosen to hit me, and
Yes,
the
sir.
weapon also. So these are the things where from we can infer whether is intention to cause me death or not. So can counterclaim and set off? You know what is counterclaim and set off? What is the difference
Yes, sir.
between the two, or one is the same thing?
So both
Counterclaim
are the
and set off.
different. Set off is given under Order 8, Rule 6. It is of mainly two types. One is equitable set off and other is legal set off. Set off is a kind of defense which is taken by the defendant. Uh, for set off, the cause of action must be arising before the institution of suit. But in case of counterclaim, the cause of action must be arising before the filing of WS. The set off can only be claimed in case of monetary suits where the money is involved. However, counterclaim can be claimed in any type of cases.
Can both these be claimed by the defendant in the same suit or different suits? Counterclaim, set off, can both these be claimed in the one suit, or he have to file separate suit for each?
So they can be claimed in the one suit itself.
Yes.
But counterclaim is treated as a separate suit because it gives a different cause of action and it may arise from different
Counterclaim,
transactions.
you mean separate suit has to be filed?
Considered as all rules of it has to file a response, which is considered as a WS in reply of a counterclaim.
What is the difference between punishment, the wrongful restraint and wrongful confinement?
A person is restricted within the circumscribing limits. He can move within those circumscribing limits. Out of those limits, he is refrained from moving.
Okay. Over to Miss Shivangi. Madam, take charge now.
Hello, Shalab. What is the difference between civil law and common law?
Ma'am, in case of common law, it means that The law which is evaluated through the judgments, common law, which we consider as a common law. However, a civil law is this, which is considered as a statutory part, and the interpretation of that part has been done by the judiciary.
Okay. Can you explain me the concept of strict liability?
Yes, ma'am. Ma'am, the general rule is that a person can only be liable if he has committed any fault. However, strict liability is an exception to this rule, and even in the case of no fault, a person can be held liable. Uh, this rule was laid down in Reynolds versus Fletcher case.
What is its import in criminal law? Is it part of criminal law also?
Yes, ma'am. In certain kind of offenses where mens rea is not an essential ingredient, certain those kind of offenses are known as strict liability offenses.
Okay. Can you give some examples of it?
Yes, ma'am. And bigamy is an example. Kidnapping from lawful guardianship is also an example of strict liability offenses.
Okay. As sir pointed out, you are a very religious person. You read a lot of religious text. So, if a matter comes to you which is in conflict with your personal beliefs, how are you going to handle such a case?
Ma'am, I believe that personal beliefs are made so that a person's life can smoothly run. Such beliefs are not made uh, to to have a conflict with that or to do injustice with other person. So my personal beliefs will be different. Actually, I will have no personal beliefs when I will be sitting as a judge, because on the when I am sitting as a judge, I have to give judgments on the basis of the evidences produced before me.
Is it possible for any person to not have personal beliefs?
Having a personal belief is different, but exercising those personal beliefs while acting as a judge is different. A person may have personal belief, but when he is doing official duty, he should refrain himself for exercising his personal beliefs while acting as a judge.
Okay. What is the governance structure of Delhi? Under what provision of the constitution is it provided?
Article 239E.
Okay. And what does it purports?
Article 239A establish the Legislative Assembly for the National Capital Territory of Delhi, in which the Chief Minister is appointed by the President, and the Council of Ministers shall not exceed 10% of the total Legislative Assembly seats. And in there will be an LG who shall act in accordance with the aid and advice of the Council of Ministers of Delhi.
Okay. So, what is the division of power between? Can you recall any recent case where the division of power was clarified? How the powers are divided between the state in Delhi, state legislative assembly, and center?
Recently, Honorable Supreme Court held that except in case of and public order land, and one more ground was there.
Yes.
Uh,
Yes.
Except on these three grounds, the state legislative assembly has all powers to make a law on those subjects matter.
Okay. What do you understand by the concept equality before law?
Equality before law is a negative concept originated in England. According to this, before law, every person is equal irrespective of any post, position, status.
Okay. Do you think in any circumstance can the concept of equality be absolute?
Ma'am, as per my limited knowledge, the concept of equality cannot be absolute, because a society has in homogeneous society only the concept of equality can be absolute. But if we consider our Indian society, it is heterogeneous in nature. There are different kinds of person, different kinds of religion, caste, communities. So it is not possible that absolute equality is possible in India.
Okay. His homosexuality legal in India?
Yes, ma'am. Homosexuality is legal, has been legalized in India when Section 377 was declared unconstitutional in Joseph Shine case. Sorry,
Okay.
Navpreet Singh Johar case.
What about the same-sex marriages? Are they also legal?
Ma'am, this issue came before the Supreme Court in Supriyo Chakravarti versus Union of India, and the Supreme Court held that there is no fundamental right to marriage under Article 21, and that is why the LGBT community has no right to marry in the present laws.
What are your personal belief on the matter?
Ma'am, since LGBT community are also humans and they are also have Article 21 in our Indian Constitution. So if all other persons, those are heterosexual persons, if they have a right to marry in statutory laws, so on the same line, on the basis of gender or sexual orientation, there should not be any discrimination, and they should also have a right to marry.
Okay. Okay. Over to Karan, sir.
Shalabdeep, right?
Yes.
Is it a Sanskrit word or this is a Hindi word?
Sir, actually, there is no Hindi meaning of this word. There is a Urdu meaning of this word, which is known as parwana.
Can you repeat?
Sir, there is the meaning of this word is in Urdu. There is not exact Hindi meaning, which is known as parwana.
Parwana.
Yes.
Okay. So, which subject do you like the most, Shalab?
The Code of Criminal Procedure.
Code of Criminal Procedure. Okay. What is this RUCA? Have you heard about this word RUCA in CRPC?
Sorry, sir, I have not heard this.
Okay. What is charge?
Sir, charge is a precise formulation of allegations against the accused.
Why the charges are not framed in summon case trial?
When the accused is produced before the court, the substance of allegations are directly stated to him. And
This can be done in warrant cases also. Why we are following lengthy procedure in warrant cases by
the
framing the
warrant cases are considered as serious in nature, and that is why it is necessary that every proceedings should be in written, as well as the all rights should be availed to the accused, and whatever formulation of allegations are made against the accused, those should be written and should be explained to the accused.
what purpose, or we can say that what object we are basically achieving by framing a charges against the accused person.
Sir, the concept of natural justice is preserved when the charges are framed and they are actually explained to the accused so that he can defend himself in relation to those charges.
So in summons trial cases, we are not preserving this concept of natural justice because we are not framing charges against the accused as per your answer.
Sir, the summons cases are not serious in nature, and it is sufficient when the substance of the offenses of allegations are stated to him and they are petty in nature. So there is no need, as per the statute, to follow the lengthy procedure.
Okay, fine. Goelji, what's your take on UCC versus religious beliefs?
The UCC versus religious belief.
Yeah, is UCC curtailing the religious beliefs of a person?
UCC is basically a constitutional mandate which is given under Article 44, and a state shall endeavor to make a UCC. In UCC, all laws related to marriage, intestate succession, and divorce, and all related matrimonial issues are to be dealt. But if we see that right to religion, which is, as you said, that religious beliefs are to be conflicted. So if we see Article 25, it is not an absolute right. It is subject to public order, health, and other fundamental rights. So if UCC is enacted, then it cannot be considered that a person's right to religion is violated, because he can still exercise his religion but that should be only codified.
You are pursuing PhD, right?
Yes, sir.
The topic for PhD is approved.
Not yet, sir, because the coursework is going on.
What's the topic of your LLM dissertation?
The changing dimensions of right to freedom of speech and expression in India.
What's your take on recent incident with respect to the latent India like episode in which Ranbir Alavadia gives a statement? Is this statement is a part of fundamental right or it violates the principles of fundamental rights?
Sir, Article 19(1)(a) provides freedom of speech and expression to all citizens. However, the restrictions can be imposed on that right under Article 19(2). And one of such ground is decency and morality. So any statement, if it is given by any person or any citizen, which is in contradiction to decency and morality, that can not be considered as a freedom of speech and expression. So whatever Ranveer Alabadia said, it cannot be said that it is a part of speech and expression, as per my view, because somehow it violates the decency and morality of our society.
So is the statement given by the Ranbir Alavadia is punishable under any law?
Yes, sir. It is punishable in BNS, but I can recall the provision of IPC because I don't know the exact provisions of BNS.
Okay, fine. Thank you. Over to Mohit, sir.
So only the last question. So can the judicial magistrate ask any question relevant to the witness when he is in the cross-examination, course of cross-examination, where the defense counsel is cross-examining? Can
Yes.
magistrate put any question to the witness?
If we see section 165,
Hmm.
the power has been given to the magistrate when the trial is going on. He can ask any question to any witness.
To list the truth. Yes, ample powers given to the judicial officer. Any relevant, irrelevant, he can put any
Yes.
question. There is no bar on this power. Overall performance is very good. You are well dressed. We wish you all the best.
Thank you, sir.
Shalabh, I think you have good clarity of law. What I feel is you're lacking somewhere in the confidence, and I don't find no reason for you to be lacking in confidence somewhere. Okay, so I think you take a time when you hear a question, structure the answer, and then you can say it with a smile. Be relaxed, be calm. Okay, you don't have to be serious. And all the best. I think you did well.
गोयल जी, आपको नॉलेज अच्छी है जैसा मैम ने बताया. कॉन्फिडेंस मुझे भी थोड़ा सा ऐसा लगा कि आप कॉन्फिडेंस में लैग कर रहे हो, राइट? आई डोंट नो. लॉ की नॉलेज अच्छी है, कॉन्फिडेंस लैग कर रहा है, थोड़ा सा कॉन्फिडेंस इंप्रूव करो अपना. और वन मोर थिंग कि जब पैनल में क्वेश्चन पुट किया जा रहा है, प्लीज लिसन प्रॉपरली, क्वेश्चन को ध्यान से सुनो, राइट?
Okay.
हरी अप मत करो कि हाँ मैं अभी आंसर दे देता हूँ. देयर इज नो रिक्वायरमेंट. एंड व्हेन यू आर सेइंग सीआरपीसी इज योर फेवरेट सब्जेक्ट, मेक श्योर कि आपको ऑलमोस्ट सब कुछ पता हो. रुका इज वेरी बेसिक टर्म. इसके बारे में आप पढ़ोगे तो बहुत बेसिक टर्म है रुका. ऑन ए रेगुलर बेसिस इसको यूज किया जाता है पुलिस ऑफिसर के द्वारा जब क्राइम सीन को वो इन्वेस्टिगेट करते हैं, राइट? रेस्ट यू आर गुड टू गो. बेस्ट ऑफ लक, बेस्ट ऑफ लक.
Yes, sir.